On January 22, 2022, the branch manager of the Natchitoches Parish Library, Rosalind Parker, called 911 for the Natchitoches Police Department requesting an officer. Lines 28 to 32 LASC 0294 Line 1. Ms. Parker indicated, "There is a patron here acting very strange." She further stated the defendant was wearing a green army jacket and was holding two backpacks. Ms. Parker testified at trial consistent with her 911 call to police. In fact, Officer Davis's body cam footage captures the dialogue of Ms. Parker informing Officer Davis again of defendants' weird actions of checking emergency exits and entering restricted access areas to the third floor. This footage was captured on police body camera prior to Officer Davis' entry into the building and prior to Officer Davis' contact with defendant on the second floor of the Natchitoches Parish Library. At trial, Ms. Parker testified that she and her coworker Carlo Jimenez were both on the second floor of the library when she observed defendant with two large bags looking very angry while he checked exit doors. The defendant first looked up towards the third floor. Ms. Parker asked if she could help him, and according to Ms. Parker, the defendant answered aggressively, "What is it you would like to help me with?" She replied, "Sir, I'm just asking a question." Defendant went upstairs to the third floor and discovered it was locked. According to Ms. Parker, her coworker Carlo stated, "He can't go up there." Defendant returned to the second floor. Ms. Parker testified that at that point she and Mr. Jimenez became very alarmed. Mr. Carlo Jimenez corroborated Ms. Parker's testimony by indicating that he observed the defendant walking to the stairs and answering Ms. Parker very rudely. Mr. Jimenez indicated that the defendant was looking for emergency exits, cameras, and that the defendant appeared to be casing the place. Mr. Jimenez testified that he was very scared for his life considering current events in the world, and he thought the defendant was putting together a gun. After these observations by Mr. Jimenez, Ms. Parker called the police. After calling the police dispatcher, Ms. Parker testified that she and Mr. Jimenez continued hearing very loud banging noises that sounded like defendant was taking a lot of stuff out of the backpacks. These actions continued to cause a concern. Ms. Parker testified that it was her responsibility to watch for safety concerns at the library as the manager. She further testified that given how the world is today with people showing up in churches and public places shooting, and the Boston bombing which was based on a backpack, she was honestly concerned about the defendant's behavior and felt that she was being vigilant by contacting police. After receiving a call of a white male wearing a green army jacket acting suspicious, checking doors to see which ones were locked or not locked as if he was casing the place. This dialogue is captured and characterized in the testimony of Ms. Scott. Officers Davis and Favors arrived at the library together. Police body camera captured the initial investigation phase in which officers gathered information from Ms. Parker when they arrived. Officers then went upstairs to the second floor where they observed the defendant, who matched the description provided by the dispatcher and Ms. Parker. Officer Davis testified that he observed Mr. Jimenez, the librarian, who pointed toward the direction where the defendant was standing near the magazine section. Officer Davis became concerned upon observing how fearful Mr. Jimenez looked. Moments later, Officer Davis spotted defendant standing in a corner in the library. According to Officer Davis's testimony, the defendant turned around and faced him. Officer Davis further testifies, as the defendant turned around, an image popped up on his computer. The image was pornographic in nature. Officer Davis further described, a majority white screen about 2/3 and then the top banner, and on each side of the banner it had the bare posterior of two women. The one on the right showing her bare buttocks and vagina. He stated that the combination of the information provided by the librarians and having seen the images, he became very uneasy. At that point, he describes that he and Officer Favors assumed a tactical stance, positioning themselves deliberately to prevent the suspect. Travis Hines from leaving and Officer Davis engaged the suspect, asking the defendant, "What is your name?" as captured on body camera viewed in open court. Officer Davis testified that he asked the suspect his name twice with no response. The body camera video captures Officer Favors asking the defendant his name one time. The defendant did not reply. Officer Thurman Miller appeared in the video and assumed the tactical stance jointly with Officer Davis and Favors. Officer Davis testified that defendant, the suspect at this point, was not free to leave. Officer Davis testified that defendant was detained. And Officer Davis further indicated that he and his fellow officers formed a protective group around the defendant, a triangle so that defendant could not leave. Officer. Then, after Miller identifies himself and asks defendant for his name, stating, "Well, I'm Officer Miller with the Natchitoches Police Department. We got a call about a suspicious person. What is your name?" In his response, he did not provide his name. According to Officer Davis, based upon the total investigation, it was determined that all officers had reasonable suspicion to believe some criminal activity was or was about to be committed. Defendant failed to provide his name as asked by the officers over at least 4 occasions. Multiple officers on the scene repeatedly asked for identification. Defendant continued to resist by his failure to provide his name. Therefore, defendant was arrested for his failure to provide his name in violation of the law during an investigation and detention. Officer Favors, in fact, stated to defendant that she had reasonable suspicion of a crime and that defendant should provide his name. Pursuant to request of the defendant, a trial of this matter was held on April 11, 2022. Upon completion of a 6-hour bench trial, defendant was found guilty in violation of LARS 14-108 BC, resisting an officer by failing to provide his name when an officer had reasonable cause to believe that a crime was being committed or was about to be committed. The trial judge opined that the defendant intensively created suspicious circumstances. There was no other reason to check all doors to the building. Significantly, the defendant set up a recording and video device. The judge indicated, "I think you created the circumstances so that you would create reasonable suspicion that the police would be summoned, and they were." RPLASC 0510-31-32. And the defendant was found guilty and sentenced in due course. Defendant filed a writ of certiorari, challenging his conviction to the Third Circuit Court of Appeals, asserting errors that the evidence was insufficient for the trial judge to have found him guilty of LARS 14-108 resisting an officer, and that the trial court was in error in allowing the trial to proceed without counsel for defendant. The Third Circuit Court of Appeal found that the evidence was sufficient for the finding of guilt, however vacated the conviction based upon the right to counsel issue. Defendant now lodges a writ of review to this court of Louisiana regarding the issue of sufficiency of evidence. Law and argument. Defendant's sole assignment of error alleges that the evidence was insufficient to find him guilty of LARS 14-108, resisting arrest for failure to provide name to law enforcement officer during detention. The defendant's sole assignment of error can be divided into 2 parts, A and B. Part A will address the sufficiency of the evidence. Part B will address allegations that law enforcement did not have reasonable suspicion to justify a stop. Sufficiency of evidence. The seminal case on appellate review of sufficiency of evidence is Jackson v. Virginia, 443 U.S. 307, 99s.ct. 2781, 61L.ed.2d 560. In that case, the United States Supreme Court recognized that a reviewing court may be called upon to decide whether the state has established the guilt of the accused beyond a reasonable doubt. The purpose of such a review is not to second-guess the jury or to substitute the opinion of the appellate court for that of the fact-finder. The purpose is to ensure that due process has not been violated. The Supreme Court stated the law as follows. The critical inquiry on review of the sufficiency of the evidence is whether the record evidence could reasonably support a finding of guilt beyond a reasonable doubt. But this inquiry does not require a court to ask itself whether it believes that the evidence at trial established guilt beyond a reasonable doubt. Jackson v. Virginia, Supra, 99s.ct. At 2788 to 2789. The court continued. Instead, the relevant question is whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements beyond a reasonable doubt. 99s.ct. At 2789. This preserves the important role of the fact finder to resolve conflicts in testimony, to weigh the evidence, and to draw reasonable inferences from basic facts to ultimate fact. ID. It is clear that the sufficiency review mandated by Jackson v. Virginia, Supra, does not involve review of the rational credibility determinations of the finder of fact. In State v. Muscle, 523 So.2d 1305, Law. 1988, the Louisiana Supreme Court analyzed Jackson v. Virginia, Supra, and discussed the role of the appellate courts in reviewing criminal convictions. If the court finds that no rational trier of fact viewing all of the evidence from a rational pro-prosecution standpoint could have found guilt beyond reasonable doubt, the conviction cannot stand constitutionally. The actual trier of fact's rational credibility calls. Evidence weighing and inference drawing are preserved through the requirement that upon judicial review all of the evidence is to be considered as if by a rational fact finder in the light most favorable to the prosecution, and by the admonition that the sufficiency inquiry does not require a court to ask itself whether it believes that the evidence at trial established guilt beyond a reasonable doubt. Thus, the reviewing court is not called upon to decide whether it believes the witnesses or whether the conviction is contrary to the weight of the evidence. The Louisiana Supreme Court addressed the consideration of circumstantial evidence on appeal in State v. Castile, 448 So. 2d 676, wherein the court stated, when a case involves circumstantial evidence, and the jury reasonably rejects the hypothesis of innocence presented by the defendant, that hypothesis fails, and the defendant is guilty unless there is another hypothesis which raises a reasonable doubt. Applying these principles of law to the facts in this case, the defendant's assignment of error is without merit. The charged offense in this case is Laws 14:108 resisting an officer, which is defined as a. Resisting an officer is the intentional interference with, opposition or resistance to, or obstruction of an individual acting in his official capacity and authorized by law to make a lawful arrest, lawful detention, or seizure of property, or to serve any lawful process or court order when the offender knows or has reason to know that the person arresting, detaining, seizing property, or serving process is acting in his official capacity. C. Refusal by the arrested or detained party to give his name and make his identity known to the arresting officer or detaining officer, or providing false information regarding the identity of such party to the officer. The facts developed at trial were: on January 22, 2022, the branch manager of the Natchitoches Parish Library, Rosalind Parker, called 911 for the Natchitoches Police Department requesting an officer. RPLASC 0293 lines 28 to 32. LASC 0294 line 1, Miss Parker indicated, there is a patron here acting very strange. She stated the defendant was wearing a green army jacket and was holding backpacks. Miss Parker testified at trial consistent with her 911 call to police. Miss Parker further testified that she and her coworker Carlo Jimenez were both on the second floor of the library when she observed defendant with two large bags looking very angry while he checked exit doors. Mr. Jimenez indicated that the defendant was looking for emergency exits, cameras, and appeared to be casing the place. Mr. Jimenez testified he was very scared for his life considering current events in the world. Mr. Jimenez testified that he thought the defendant was putting together a gun. After calling the police dispatcher, Ms. Parker testified that she and Mr. Jimenez continued hearing very loud banging noises that sounded like defendant was taking a lot of stuff out of the backpacks, causing concern. Ms. Parker testified that she was responsible to watch for safety concerns at the library as the manager. Officer Davis engaged the suspect, asking defendant, "What is your name?" This dialogue is captured on body camera viewed in open court. Officer Davis testified that he asked the suspect his name twice with no response. The video captures Officer Favors asking the defendant his name one time. The defendant did not reply. Officer Miller identified himself and asked defendant for his name, stating, "Well, I'm Officer Miller with the Natchitoches Police Department. We got a call about a suspicious person." "What is your name?" The suspect failed to provide his name. Considering all of the facts developed at trial, the trial judge could have, and did, determine rationally, considering the evidence in a light most favorable to the prosecution, that the defendant failed to provide his name to officers when there was reasonable suspicion to believe that a crime may have been, or was about to be committed. Defendant's failure to provide his name was a clear violation of Louisiana law. B. The trial court properly found that the police had a reasonable suspicion under Lars 14:108 to require defendant to provide name. Louisiana Code of Criminal Procedure Article 215.1 states in pertinent part, a law enforcement officer may stop a person in a public place whom he reasonably suspects is committing, has committed, or is about to commit an offense and may demand of him his name, address, and an explanation of his actions. To justify an investigatory stop, an officer must have reasonable suspicion of criminal activity. State v. Boss, 04-457, page 5, Law App. 5 CIR 1026-04, 887 So.2d 581, 585. Reasonable suspicion is something less than probable cause to arrest. Requires that police officers have sufficient knowledge of facts and circumstances to justify an infringement of the individual's right to be free from government interference. State v. Chauvin, 06-362, pg. 7, 945 So.2d 752, 757-58. Absent reasonable suspicion, an investigatory stop is illegal and the evidence seized as a result is inadmissible. Boss, 04-457 at 5, 887 So.2d at 585. The determination of reasonable grounds for an investigatory stop does not rest on the officer's subjective beliefs or attitudes, but is dependent on an objective evaluation of all the circumstances known to the officer at the time of his challenged action. Lane, 09-179 at 5, 24 So. 3D at 924. In determining whether the officer acted reasonably in such circumstances, due weight must be given, not to his inchoate and unparticularized suspicion or hunch, but to the specific reasonable inferences that he is entitled to draw from the facts in light of his experience. Sam, 08-220 at 5-6, 988 So.2d at 769. An anonymous tip may provide probable cause for an arrest. Illinois v. Gates, 462 U.S. 213, 103 S.ct. 2317, 76L.ed.2d 527, or reasonable suspicion for an investigatory stop. Alabama v. White, 496 U.S. 325, 110 S.ct. 2412, 110L.ed.2D 301, if it accurately predicts future conduct in sufficient detail to support a reasonable belief that the informant had reliable information regarding the suspect's illegal activity. State v. Smith. 00-1838, page 1, 785 So.2d 815, 816. See also, Lane, 09-179 at 5-6, 24 So.3d at 924, citing Alabama v. White, 496 U.S. 325, 110 S.ct. 2412, 110L.ed.2D 301, Boss, 04-457 at 6, 887 So.2d at 586, citing Alabama v. White, 496 U.S. at 332, 110 S.ct. 2412, State v. Leonard, 80 So. 3D 535. In the case before this court, defendant, Hines, was in a public library and public space as required by law that triggers Code of Criminal Procedure Article 215.1. The librarian, Rosalind Parker, nervously contacted the dispatcher indicating that a white male wearing a green army jacket had entered the library. Ms. Parker indicated that defendant was wearing a backpack and had gone to exit and entry doors to check whether the doors were locked or unlocked. The complainant described that the suspicious person had attempted to gain entry to the third floor, which is locked and a restricted area. The librarian inquired of the defendant whether he needed assistance. He replied, "Do I need help with what?" Ms. Rosalind Parker described the defendant's behavior as very weird and suspicious. She was afraid. Once police arrived, she began whispering because she was afraid and she started crying. Body camera video shows defendant in area that is restricted and that is encompassed with. Officer Davis testified that the defendant matched the description of the person described by dispatch and later by the librarian and corroborated by the officers. Police observed recording equipment, a backpack with unknown contents, and Officer Davis observed a computer with naked or pornographic images on the computer. All of these articulated facts taken together along with the combined experiences of the officers and the concerns and fears expressed by library staff formed a totality of the circumstances provided reasonable suspicion that criminal activity might be afoot. This reasonable suspicion required an investigatory stop and identification of the defendant to determine whether a crime was being committed or about to be committed. Defendant short-circuited this legal process by his failure to provide his name. A rational trial judge, after hearing the evidence, found that the evidence was sufficient to prove that the defendant failed to disclose his identity as required under Code of Criminal Procedure Article 215.1 and Lars 14.108 and therefore violated prevailing Louisiana law. The United Supreme Court, in a litany of cases subsequent to Terry v. Ohio, has repeatedly indicated that police may require the name of persons while conducting investigations. Defendant, Hines, failed the clear pronouncement of law that he must at a minimum provide his name in response to an investigatory stop where police have determined reasonable suspicion for the temporary stop. Asking questions is an essential part of police investigations. During suspicious events, a police officer is free to ask a person for identification without implicating the Fourth Amendment. Interrogation relating to one's identity or a request for identification by the police does not, by itself, constitute a Fourth Amendment seizure. Enns v. Delgado, 466 U.S. 210, 216. Beginning with Terry v. Ohio, 392 U.S. 1. The court has recognized that a law enforcement officer's reasonable suspicion that a person may be involved in criminal activity permits the officer to stop the person for a brief time and take additional steps to investigate further. Defendant repeatedly did not identify himself when officers had reasonable suspicion that a crime may have been committed or was about to be committed. He was arrested for that failure to identify himself. Conclusion. Evidence and testimony was heard for more than 6 hours before the trial judge. Certainly, the judge determined credibility of the parties and weighed the evidence and testimony. The state proved that the defendant resisted an officer by failing to identify himself when there was reasonable suspicion to believe that a crime was being committed or was about to be committed. The defendant caused the disturbance that created his peril by creating a circumstance that caused attention to himself such that library staff were alarmed and afraid. The library staff acted responsible and reasonably in response to their fear. They called the police as normal people do on countless occasions to investigate the incident. The trial judge opined that defendant caused the suspicious circumstances. Defendant cannot now claim that police were wrong for investigating the incident caused by him. Moreover, he cannot claim that the police are wrong for asking his name while investigating an incident of his own creation. Therefore, the city of Natchitoches avers that the trial judge and Third Circuit Court of Appeal findings that there was sufficiency of evidence to find defendant guilty of the offense of resisting an officer should not be disturbed.